Imagine a cherished family home filled with decades of memories and love. Now, imagine that same home, after a loved one has passed, suddenly becoming a source of tension among those who loved them most. It is a common and often heartbreaking scenario, yet one that can be navigated with the right approach. When heirs disagree on inherited property, the situation can unfortunately range from minor squabbles to serious legal battles, profoundly impacting family relationships and potentially diminishing the value of the asset itself. Essentially, unresolved disagreements necessitate a formal path toward resolution, which can involve negotiation, professional mediation, or, in some cases, intervention by the court system. The root of these disagreements often stems from a complex mix of deeply personal emotions, differing financial needs, and varying expectations about the property's future. For example, one heir might passionately desire to keep the property as a sentimental family gathering place, wanting to preserve its legacy, while another urgently needs to sell it immediately for pressing financial reasons. Legal ownership structures also play a significant role. If the property is held as tenants in common, each heir owns a distinct, undivided share that can be sold or willed separately, making joint decisions more complex. In contrast, joint tenancy with right of survivorship means ownership automatically passes to the surviving owners, avoiding probate for that asset but still requiring agreement on its future. Furthermore, unequal contributions to the upkeep or emotional investment in the property over the years can fuel significant resentment and make compromise difficult. Navigating these emotionally charged waters effectively begins with establishing open and honest communication among all heirs, ideally facilitated by a neutral third party like a professional mediator. This mediator can help ensure everyone feels heard and understood. Start by clearly articulating each person's individual needs, their hopes for the property, and any underlying fears or concerns. Explore various practical options, such as one heir buying out the others at a fair market price, selling the property on the open market and equitably dividing the proceeds, or even creating a detailed co-ownership agreement for shared use if that is a valuable path. Consulting with an experienced estate attorney early on can provide invaluable clarity on each heir's legal rights and responsibilities, offering a structured, objective approach to finding potential solutions that protect everyone's interests. While often considered a last resort, a partition action is a specific legal remedy where a court can legally compel the sale of a property and distribute the proceeds equitably among co-owners if they simply cannot reach a consensus. This process, however, typically involves substantial legal costs and can unfortunately exacerbate family strain. A far more advantageous approach involves proactive planning by the original owner. This means clearly outlining their wishes for the property and its disposition within a well-drafted will or trust. Such documentation serves as a crucial blueprint, significantly reducing the potential for future disagreements and easing the burden on grieving family members during an already difficult time. Ultimately, successfully handling disagreements over inherited property requires a combination of patience, genuine empathy, and a pragmatic willingness to compromise. By prioritizing clear and respectful communication, actively exploring professional mediation as a constructive tool, and thoroughly understanding the legal pathways and options available, families can significantly increase their chances of finding a fair and agreeable resolution. This approach not only helps to honor their loved one's legacy but also actively works to preserve family harmony, turning what could be a source of painful conflict into a process of constructive solutions.